All right, welcome back to another national PSI Real Estate Exam prep. And today we're going to talk about 5 questions around agency duties to client. And on the national exam, there are going to be plenty of questions around the brokerage relationships, agency relationships, and you're going to have a pretty solid understanding around this topic. And so, question number one, a broker who represents a seller under an exclusive agency listing receives 2 offers for the property at the same time, one from one of his salespeople and one from a salesperson of a cooperating broker. What should the broker do? And as we're looking through these answers, we know that we have to submit both offers at the same time. And the reason for this is the seller's obligated to reveal all offers unless they're explicitly instructed not to. And we cannot favor one brokerage over another one, even if they are a rival company. And additional, that we need to actually present all offers, high, low, regardless of when they were received, even if we're under contract on the property and another offer comes in, we still must disclose the offer as they're still coming in. Question number 2. A seller has told the listing agent that the agent must only represent the seller in the sale of the property. In this case, the first guide for the agent is to obey. Looking through the answers, we land on A, all lawful instructions of the owner. And the reason is the seller's real estate broker is required to follow all lawful instructions given by the owner. If there are any modifications to the common law of agency due to a state agency statute, the broker must adhere to the statute's provision. We do not have to participate in dual agency. And when we're looking at this caveat emptor, guys, that's only on the buyer. And it's so that the buyer can actually go through and do all their due diligence around before purchasing goods and services. So this does not relate to this question at all. Number 3, a listing agent's duty of care to a seller includes all of these except. And as we're looking through these answers, making reasonable efforts to market the property, helping the seller arrive at a realistic listing price and commission splits for the MLS entry, helping the seller evaluate an offer to purchase and write a counteroffer if needed. All those sound pretty solid, like that is our job description. And then we get to D, sharing the seller's financial situation with a buyer in order to expedite a sale. Like, we are never going to do that in most all scenarios. It says to ensure the seller's interests are protected, an agent representing them is prohibited from sharing confidential information with a buyer unless they have received explicit permission from the seller to do so. The restriction applies even if the agent believes it may help expedite the sale of the property. All the other actions mentioned are instances where the agent fulfills their duties of care towards the seller. So there's going to be very few, if never, you will run into the situation where you disclosing your seller's financial situation will be helpful. And everything else, A, B, and C, are absolute day-to-day operations of what you will experience as a real estate agent. Question number 4. A salesperson is working with a young married couple expecting a child who are buying their first home. The couple has found a home that they want to make an offer on. And in completing the offer, the salesperson explains the options for taking title and then asks the couple how they want to take it. The couple state that they're still not sure what will be best for them and their family. The salesperson should what? And as we're looking through these answers, we're going to land on B. We're going to recommend that they speak to an attorney. And the reason for this is that we're not allowed to provide recommendations on how title should be taken. However, it's within our responsibilities of a competent real estate professional to suggest that the buyer seek guidance from an attorney who can offer appropriate advice in these matters. And question number 5. A seller agreed to list his home for $220,000, but the listing agent did not tell him that the fair market value of the home was actually $245,000. The listing agent purchased the property the next day. The agent has violated which of these duties to the seller? And as we're looking through these answers, we land on D, loyalty. The fiduciary duty of loyalty obligates the agent to prioritize the client's interest above everything else, even their own self-interest. Agents are accountable for the money and property belonging to others that they handle while performing their duties as a part of the duty of accounting. The duty of care mandates that the agent utilizes their expertise and experience for the client's advantage. The duty of disclosure entails keeping the clients well informed about pertinent facts pertaining to the transaction. All right, well, I hope that was helpful. This was agent's duties to the client. This was 5 questions around subject matter that we think that you will see on your national real estate exam through PSI. Stay tuned next week for another video to help you crush your real estate exam and become a licensed real estate agent.